Your legal protections plus 3 warning signs, they're building a case against you and exactly how to fight back. You got hurt at work, you filed a workers' comp claim, and now something feels off. Your boss isn't looking at you the same way. Your schedule just changed out of nowhere. Maybe you got written up for something that never mattered before. And there's this voice in the back of your head saying, something's not right. Are they trying to get rid of me? Here's what you need to know. If you're feeling that way, you're not paranoid. Because what I'm about to show you are the 3 specific warning signs that your employer is building a paper trail to use against you, to fire you. And more importantly, exactly what North Carolina law says that you can do about it. I'm Ken King. I've practiced workers' comp law in North Carolina for years, and I've seen this playbook over and over again. Let's break it all down. Let me give you the short answer first. No, your boss cannot fire you for filing a workers' comp claim in North Carolina. That happens to be illegal. North Carolina General Statute 97.6.1 states that no employer shall retaliate against an employee for filing or attempting to file a workers' compensation claim. In addition, North Carolina law has a separate law called the Retaliatory Employment Discrimination Act, or REDA. REDA makes it illegal for your employer to fire you, demote you, or even to cut your hours, or create a hostile work environment because you exercised your right to file a workers' comp claim. So the law was on your side, but here's where it gets complicated. North Carolina is an at-will employment state. That means your employer can fire you for almost any reason or no reason at all, as long as it is not an illegal reason. They can't fire you for filing a workers' comp claim, but they can fire you for being late, for violating a policy, for poor performance, for restructuring. They won't say, we're firing you because you filed a claim. Instead, they create a paper trail that looks legitimate on its face. The difference between lawful termination and illegal retaliation often comes down to timing and patterns. And there are 3 warning signs that can reveal what's really happening. Warning sign number 1, sudden write-ups. You've worked at your job for years with no issues. Then you file a workers' comp claim, and suddenly you're being written up for minor infractions that were never enforced before. This tactic is often called papering the file. The goal isn't necessarily to discipline you immediately. It is to build documentation so that if they terminate you later, they can point to a record of performance problems and argue it wasn't retaliation. If you have ever prior disciplinary history and suddenly begin receiving multiple write-ups, you have a problem. The timing may not be coincidental. Warning sign number 2, schedule changes. Your long-standing schedule suddenly changes. Your hours are reduced. You've moved to a less favorable shift. You're reassigned to a more difficult location or job. Instead of firing you outright, the employer makes your situation uncomfortable enough that you feel pressured to quit. This can amount to constructive discharge. Under REDA, forcing someone out through intolerable changes can be treated similarly to direct termination. Warning sign number 3, restructuring. You're told your position has been eliminated or restructured, but your role is the only one affected. Or someone else is hired shortly afterward to perform essentially the same job, but under a different title. Under REDA, you must show that filing your workers' comp claim was a substantial factor in the adverse action. Timing can serve as important evidence. If your position disappears shortly after you filed a claim, that sequence of events may support an inference of retaliation. How should you respond? If you see these warning signs, take action carefully and deliberately. First, document everything. Keep copies of write-ups, emails, schedules, and messages. Write down conversations with dates and details. Think carefully before resigning. Quitting can make proving retaliation much more difficult. Third, consider filing a REDA complaint with the North Carolina Department of Labor. You generally have 180 days from the retaliatory action to file. Missing that deadline can bar your claim. If you have already been terminated, REDA may allow you to seek reinstatement, back pay, and other remedies. Employers may assume that fear, confusion, or financial pressure will prevent employees from asserting their rights. But understanding the law, recognizing the warning signs, and acting within the required deadlines can protect your position under North Carolina law. If you have been terminated, take immediate steps to protect yourself under REDA and the Workers' Comp Act.